So what were the charges on you?
Charges were sexual assault, sexual exploitation. I was presenting my evidence, and then ultimately the judge has to be recused. My application of complaint to remove the Crown Attorney because she had violated the oath of Crown Attorney, how the system is broken and how the Crown Attorneys treat self-represented people who don't have a lawyer. So I filed the case against judge, I filed the case against Crown Attorney. This is my application which I filed against police. It destroyed me physically, it destroyed me mentally, it destroyed me financially. This is an email or a message from the brother of the complainant after I'm charged. And what he says to me, sir, I don't understand math the way the other teacher is teaching. I like the way that you teach because you teach and explain the concept clearly. I sued police officer who charged me. I sued Peel Regional Police. Also, I sued the Attorney General.
How much amount you are suing them for?
I'm suing them for $65 million.
To Peel Police?
To Peel Police and the police officer who charged me.
Okay. Mr. Dhawan, first of all, congratulations to you for such a long fight for 4 years.
Nitin ji, thank you very much.
Sanjeev ji, what is the outcome of this case?
The outcome of this case is that the Honorable Court has stayed the charges, and so basically I am now free to start whatever I want to start in my life.
And you said the Honorable Judge, he recused himself, and what about Crown?
Well, there are two parts. The final outcome, as you asked me, was that the charges are gone. They are not there anymore. But in the whole process, Nitinji, because in the beginning when I was having a lawyer and then I lose the lawyer, when I lost the lawyer, after that, whether it was the Honorable Court or whether it was Crown, they were harassing me, they were insulting me, they were basically not even considering me a human being. Like they were treating me as you know, we in the Canadian law we say you are innocent until proven guilty, but they were treating me as a guilty until I am proven innocent. So they were treating me very badly. When I was telling the Honorable Judge that I have the evidence what Crown Attorney is saying she's wrong and she's lying in the court, and the judge says, oh, I go by the words of Crown Attorney and you are making up things. So they were not listening to me, and that was the problem. And that's the reason then I actually filed a complaint to the Ontario Judicial Council, the body which governs the conduct of judges. So I sent them a complaint, and they told me that unless this judge is in your case, so we cannot intervene. We can investigate him only when he is no more in your case or your case is completed. So then I have to be before the judge again because no one is ready to listen anything. Then I filed a case against the judge's misconduct that he is biased, and then the rule, unfortunately, Nitinji, is that if you file a case against the judge that he is biased, no one else can hear that case.
Okay.
The judge against whom this case is, he's going to listen the case. So I filed the case. I had almost 7+ hearings. From morning to evening, I was presenting my evidence, and then ultimately the judge has to be recused, and he wrote a ruling. We will talk about that ruling at a later part of this.
So what recusal means? What is meaning of recused?
Recusal is if you file a complaint against a judge that he is biased. So there is a way that he can be removed from the judge, but who removes him from the case? Not judge, from the case. That is, that judge himself has to decide to remove himself from that matter.
So if we got it right that after 4 years the honorable judge recused himself from the case
Yes,
and the crown was removed from the case
yes.
and the new judge was appointed.
When the old judge was recused, then the original senior judge, a judge who is the judge of the judges for almost 6 or 7 cities, including Brampton, Mississauga, Milton, Hamilton, and others. So the senior judge, original senior judge, His Honor Justice Anthony Litch, he came from Hamilton and had a hearing with me in Brampton, and there he actually decided that he said that we'll have a court hearing on 3rd of September to discuss my application of complaint to remove the Crown Attorney because she had violated the oath of Crown Attorney and she acted with malice.
Okay, we got it. Then they appointed a new judge on the
So they
case.
appointed new judge.
Okay.
And then when that case was to be heard, so what happens? The case was to be heard on 3rd of September. On 12th of August, the government removed the Crown Attorney from my case.
Okay.
And they say because what you're asking is already done, so then your application is not going to heard. But I'm going to say it here. Next week on my Facebook page, I'm going to put my whole application, which is almost 200 pages, 100 something pages of affidavit plus 100 something pages of factum. So I am going to put all those documents online on my Facebook so that people can see how the system is working, how the system is broken, and how the Crown Attorneys treat self-represented people who don't have a lawyer.
So you were representing yourself. You never had a lawyer, or you had a lawyer? You just
Nitinji, I had a lawyer in the beginning, very well educated and a famous lawyer. But at some point of time, and I have that story also.
Okay.
But I'm not going to focus on the lawyer today because then we will deviate from the real issue we want to discuss. But that also is a story that how sometimes the lawyers treat the clients. I'm not talking about that today.
Okay, so
he was there, but at some point he was gone.
Okay.
And say on 25th of February, actually 2022, he was gone.
Okay.
From that till today, I dealt my case myself as a self-represented person.
So what were the charges on you?
Charges were sexual assault, sexual exploitation.
Okay. And how many years this case went through? 4 years of
More than 4 years, and actually it's the Canadian law that for any summary offence, according to Supreme Court of Canada's decision in Jordan, it's called Jordan Clock, a case has to be dealt within 18 months.
So what was the reason for delay in the trial or the case?
First and foremost reason was the lack of cooperation of Crown to provide me disclosures.
Okay.
The documents which I had a legitimate legal right to have, that's called disclosure. So she did not provide that. She did not, whenever I sent her any information or asked any information as a self-represented, she cared not to even respond to that.
Okay.
And when I made a request to the court that I want to have a hearing about that she's not providing me the judge, and then she kept on lying to the judge.
Okay.
And I brought to the attention of judge numerous times that she's lying, I have evidence, and I asked the judge that I have evidence, where should I send?
Okay.
And he said, I don't know. And he said, you are making up things. So it was. And Nitinji, in his ruling where he recused himself on the apprehension of bias, judge admitted that Sanjeev Kumar has, I'm highlighting, it's his words, Sanjeev Kumar has proven that I was imperfect in handling my work or hearings. He also admitted that in 4 years I have not done enough to get this case. I can because
so judge admitted that.
he admitted, actually I have his exact wordings, because if I speak in my words,
Okay.
there's a possibility of sometimes changing the meaning. So whatever.
So in your case, the trial never started.
No.
So means the charges and case was against you, but you put an application of a biased and other application against the judge and against the system. So that was
So I filed the case against judge. I filed the case against crown attorney. I filed a case. I will show you here
Yes.
on the camera. This is my application, which I filed against police. That they, it's called application racket of Sanjeev Kumar regarding charter right application under section 11D and section 7. That's called destruction of evidence by police.
so you said that police. This case is against the police for destruction of evidence.
I filed
The
this
evidence
case.
was never provided to you.
Some little evidence was provided, but some evidence was not provided, and some evidence was destroyed, maybe deliberately or maybe by gross negligence. But the thing is, this application was there before the court on 4th of September 2024. Court has to hear this. I actually subpoenaed 8 police officers that I want to cross-examine them before the court to prove that their conduct was wrong. But what happened on 4th of September, the Honorable Court of Her Honor, Mabel Lai, stayed my charges. So because of that, many other applications, I have these applications where, for example, this is an application of violation of Canadian Charter of Rights and Freedoms under section 10B and subsection 24B, which is, I was not even given a lawyer to talk when I was being arrested. So there are numerous violations. This is another application regarding that. I said, I told the court, don't cross-examine the complainant. Cross-examine, let me allow to cross-examine the parents, and the truth will come. So this is an application.
So you were not allowed to cross-examine the parents.
Well, because this application was never heard by the court.
Okay.
I filed the applications,
but never
and then
heard.
what happened, that court said that your charges are stayed. So because of that, these applications, along with these 13 applications, they were not heard.
Okay.
The court decided to stay the charges rather than hearing all these applications.
Okay. Since this is a legal matter, and we put a disclaimer here that whatever Mr. Sanjeev Kumar Dhawan is saying, he is sharing his own story. In case any Crown or any legal department or any police want to make their comments, they are most welcome to put on their side also. Because we would like to hear the complainant side also. If they are ready, they can most welcome. So that's a disclaimer here. Sanjeev ji, what are your future plans now?
My future plan is, number one, I have already joined 2 colleges to do law courses.
Okay.
So I am studying with one college where I am doing the course which is called paralegal course. So that classes are starting from tomorrow, 1st of October.
Okay.
And another college, I have already started the law clerk course, which the classes started around on 11th of September.
Okay.
So I'm doing those. Along with that, because these courses will take time till I get a license to practice law.
Okay.
So I am also studying what's called mortgage things, and I have an exam in the coming 2 weeks to basically be a mortgage
Okay,
agent.
that's fine. Mr. Dhawan, like in 4 years of time, how much loss you suffered? Mentally, emotionally, financially, how much you lose?
Well,
and what about your school, which was one of the best private school here?
Well, my both schools, one of which was Guru Tegh Bahadur International School, which came number 1 in Ontario according to Fraser report. So that got closed. My Frederick Banting International School, that got closed, and I got physically sick, and I had a heart procedure on 13th of March 2023, and 2 stents were implanted in my heart arteries. So it destroyed me physically, it destroyed me mentally, it destroyed me financially, because when I started the school, so you always take some loans from the banks and all that stuff. When they stopped me from going to school and they put a news press release, where everybody talked about me.
So reputation damage.
So reputation destroyed. So schools got closed, and all the loans which were from the bank, they came on me, and I got judgments from the banks against me for not paying those debts.
Okay.
And you know what? I could not even fight those lawsuits by banks against me, because neither I had physical strength, nor I had mental strength, nor I had financial strength. So I just concentrated on only one fight, that to get my name clear from this matter.
Okay.
Rest, whatever was damaging, happening or getting destroyed, I let it get destroyed.
Okay, Mr. Dhawan, what about the complainant, their parents? Because we heard from you only that the complainant brother was still studying from you. Because in the South Asian families, if any of their daughter is assaulted by a principal, then they will never send their other kid, boy or girl, to the same principal. What is the story behind that?
Nitinji, I am putting this on this because this is a public record. This is not something.
What is this?
This is a email or a message from the brother of the complainant after I am charged. So if you see here, this message is dated November 10, 2020. And what he says to me, sir, I don't understand math the way the other teacher is teaching. I like the way that you teach, because you teach and explain the concept clearly. Next math class, can you teach please, sir? And then he sends me another message. After I agreed, thank you, sir, for teaching and making us successful. Happy Thanksgiving.
Okay, so this is a message from the complainant brother to you.
To me, and 6 months after I am being charged.
And their parents were endorsing that their other kids can study from you?
The parents sent a letter, email to my the teacher whom I appointed principal, that they want their son to be taught the way, without mentioning my name, but telling the way the boy is saying that you explain everything, this, in the same way that teacher should teach. But there were only 2 teachers of mathematics in the school. Everyone knew. One was the teacher who was teaching, and he didn't want it to, and the second was only me, who was the maths teacher. So
Okay.
the implication, the son or the brother of the complainant directly tells me that he wants to study from me, and he says, thanks for teaching and making us successful. So he wanted that. Parents indirectly said that.
So, did you ever thought to bring them to the court, the complainant or their parents, or did they ever attended the court in this 4 years?
Well, I basically asked the court. I filed an application, okay, and in that application there must be. I will be showing you once the hearing meeting is done, or this interview is done. I will give you the glimpse of that I filed a application in the honorable court that I want parents should be on record. I said I don't want the complainant to come and being cross-examined and her credibility is destroyed. I want the parents should come because they know the truth, and I asked the court that they should be there as witness, and I will cross-examine them. And application was there. Court has to make a decision on that application, but court did not made because the charges were already stayed.
Okay.
So otherwise they would have to had come.
You also mentioned that the complainant had a previous history in the previous schools.
I
What
have
kind of history that?
the history I'm going to talk about. It's serious. I have not told the name of the complainant here. Even I have the documents. I have redacted. I will say that don't like I can show you this is what it is, but
So can
don't.
you show these documents, because this is the complainant? Do you have authority to show this?
Well, complainant has complained against me, destroyed my 2 schools, destroyed my life, and I am responsible enough. I redacted
Okay.
the name of the complainant. I redacted her birth date.
Okay.
I redacted everything.
Okay, that's fine. So,
Okay, so these are the proofs where the previous school said to advise her that she should take a social worker.
Okay.
Okay, she need help. They actually recommended her to go to Hope 24/7.
So the question lies here, when this was the record in the previous schools, when they got admitted in your school, did you check those parameters, or you were not aware?
Well, you can't have that because you don't get these records before that student becomes your student.
Okay.
So you first admit the student and then you ask for OSR, which is called Ontario Student Record. It comes months after the student is admitted in the school, right? So they recommended she should go to Hope 24/7 institute, and I won't speak about that institute. I will simply tell you, guys, go to Google, put Hope 24/7, and this recommendation was made to the complainant when she was studying in grade 7. She was of 12-year age, and almost 5 years, or no, 3 to 4 years before. Hold on, I will check it.
Okay, that's fine.
Yeah,
Mr. Dhawan.
almost 3 years before I was being charged, or even before she came to my school.
Okay, Mr. Dhawan, we are short of time. So these all files, bundles, these binders, now whom you are suing further?
I have, even before my case was decided by the Honorable Court, I filed and I sued police officer who charged me. I sued Peel Regional Police. Also, I sued the Attorney General.
Okay.
So the case of police, I filed the statement of defense, statement of claim, and then police filed their statement of defense, and now we are in a stage of discovery. So I filed case even before my
So
case
how
was
much,
decided.
how much amount you are suing them for?
I'm suing them for $65 million.
To Peel Police?
To Peel Police and the police officer who charged me.
Okay.
Along with that, I filed a case against the Attorney General, but I was informed to file a case about Attorney General, the rules are different. You have to give them 60 days notice. So until that, your application not be heard. So then I withdrew that application, and I am in contact with the lawyers of Attorney General, and I am sending them a notice 60-day so that I can legally properly following the procedures.
Okay.
I can sue them, and I will sue them.
Okay. Mr. Dhawan, in the end, if you can give us a brief, how it started, when it started, and your journey, because we have couple of minutes left, and the final outcome. In the brief, if you can give us the...
Well, the journey is very simple. I was being charged, and then I had a lawyer, and then for some reasons, the lawyer was not there. Then I was all alone. I asked legal aid, but my wife was working. So we had a property, so I was not eligible to get any legal aid. And on the basis of that, so then I decided to fight the case myself. And that continued. The judge harassed me. The judge was biased at the time. Even though after, when I filed a case against him, I actually want to say a few things which judge said in his ruling.
Okay.
Okay. The judge gave a ruling on July 2024. I'm reading from here so that I don't want that any translation by me or any interpretation by me may become different. So I don't want to be in there. So what judge said on 7th July 2024, that he recused himself, and he said that Mr. Sanjeev called witnesses and were given opportunity to present evidence during the application. Though I called 8 witnesses, judge allowed only 3 witnesses, and the judge wrote, prosecutor did not call any evidence. He did not even cross-examine me. I told the prosecutor that please cross-examine me. I have put 47 allegations against the judge, and I have given more than 4,000-5,000 pages of evidence. Cross-examine me if any of my evidence or any of my allegations are wrong. So then judge wrote in the ruling, the evidence established that there is a reasonable apprehension of bias. He said, I found defendant's witness to be genuine during their testimony. Miss Gill complained of court's facial expressions to establish her perception of bias against the defendant. If I was smirking or making any expression that showed a closed mind, I am unaware of them and I apologize. Most compelling, however, was Mr. Sanjeev Kumar's testimony. He said, this is important now. Mr. Kumar is a thoughtful and articulate witness. This witness was also candid, transparent, respecting his perceptions and feelings. Mr. Kumar alleged that I have shown bias against him on several occasions. He has marshaled transcripts and comments of the court to establish his claims. I cannot, this is important, I can't easily dismiss his evidence as motivated by ill will or malice. Also, he said, I accepted the Crown Attorney's word. I now understand that without further explanation, this has created reasonable apprehension of bias. Then the most important line he wrote in his ruling against himself. He writes, the defendant, means me, Sanjeev Kumar Dhawan, has proven that I have been imperfect in how I handled things over the past 28 months. I have agreed with Sanjeev Kumar on some issues. And also, he said that the defendant has complained about my conduct to the Ontario Judicial Council. That complaint remains outstanding. Another thing he wrote, that this, you asked me that 4 years, what happened? He said, the matter has gone for approximately 4 years. I have not done enough to focus parties conclude the matter sooner, because this matter should have been, according to the Constitution of Canada, according to the Jordan clock, according to Supreme Court of Canada, this matter should have been done in 18 months. He also wrote in the decision, I have repeatedly stated on record, defendant did not faint or have medical episode.
So, yeah.
So he wrote all this, and he said,
we got this statement by in the honorable judge's ruling. Mr. Dhawan, you were also on a hunger strike outside the court premises.
Yes.
Why you started that hunger strike? Because we have clips from that also.
Mr. Nitin, the most important thing was that when I became self-represented, I didn't have a lawyer. So then the judge was not hearing me. I will say, Judge, Your Honor, I am providing you this evidence. He will not take it. I say, Your Honor, where should I send the evidence? He said, I don't know. When I say anything, I told Judge that Miss Burton is lying. He said that Miss Burton is not lying. Okay, she's doing her duty. So he said, you are making up. Okay, and I gave him evidences that she's lying. Okay. And then ultimately,
so when they said you are making up, then you decided I have no place to go just to start a hunger
and
strike.
Then what happened in one of the hearing, that's when I actually went on hunger strike. On 25th November 2022, I had a hearing going on. At the end of the hearing, it was decided that this hearing will continue on December 2nd, 2022. And what happens? On 29 November, judge sent me the decision on that application without letting me doing my submissions. And this is a well-known Canadian law that if you're not allowed to make your submissions, that ruling, that decision become null and void according to the Supreme Court of Canada, because the judge basically violated the principles of natural justice. And when he sent me the ruling, because I knew that we are having a hearing on 2nd, and before that he sent, then I said, what can I do? If judge is not going to listen, if judge is not even going to allow me to make submissions, and he's going to make decisions. So then I went on hunger strike.
Okay, got it. So do you think that this is one of the historical case in Canadian judiciary, because you were representing self-representation, and you are not a lawyer, you're not a paralegal, but still you fought this case. Is that a Canadian history?
It is the first time in the Canadian history has happened. I did a lot of research. I have not found any single self-represented defendant or accused who actually represented himself. He filed a claim or a case against the judge who was listening to him, and the same judge who was listening and who against whom the case was, he has to listen that case also, and he heard it, and anyone won it. It's as per my knowledge, it's first time in the history has happened.
Okay.
There may be cases where lawyers made a case against the judge,
But not a
self-represented person. And not only that, it's more history because not only judge was recused, then I filed a full case against the Crown Attorney, and before that case is heard, she was also removed. This has never happened.
Mr. Dhawan, now you are a free man. Your charges are stayed and the case is dismissed. So, what is your final message now?
Nitinji, the most important message is yes, the charges are stayed, but this is a story of two things. One, a broken Canadian and Ontarian legal system. Also, a story of hope that even if the system is broken, there is a hope, there is a silver lining that I, without even a lawyer, could fight and win and get justice. So that's important. I have sent a letter to Ontario's Attorney General and to others like the Premier and all MPPs and demanded an investigation into the conduct of Crown Attorney. So that's important because how they treat a self-represented person worse than a convicted criminal. That's the story, and I have sent it. And I believe that with this way, and also I want to say so that people can get the knowledge of the truth of the whole story, I am going to put all the material on which there is no publication ban on my Facebook page in the coming days, so that what judge did, what Crown did, whatever is legally allowed, there is no publication ban, and I'm also filing an application to the court to remove all publication ban on all materials so that people can know the truth. And I would like to say that you came into the court hearings to see what's going on, and you were the only person from the media, national or ethnic, who attended so many court hearings. And when this case is stayed, so you are the first one to ask me that come, and we want to tell your version also, because against me big stories were done when I was charged. So I really appreciate your own personal conduct, that you are a balanced person in the media who takes care of all sides.
Mr. Dhawan, thank you very much, and we wish you all the best for your future endeavors.
Thank you so much.
Thank you. So आज सीगे स्कूल प्रिंसिपल संजीव कुमार धवन 4 साल दी struggle, 4 years of fight, and he represented his case by himself, and the final result which came in September 2024 by the honorable judge, that case is dismissed, the charges are stayed, and he is a free man now. We wish him all the best.